Oh, white pine, count a line of white pine. Take me down that old dirt road. Washboard almost cleans my clothes.
Hello everyone and good morning for our third recording from the lockdown. It is another sunny morning here in France, kind of cold though, and I hope you're all doing fine and staying safe, as well as of course your families and loved ones. The topic for today is discrimination, which is actually a huge topic, and you might say even almost a subject unto itself, because it covers much broader scope, in fact, than just employment law. Although employment and labor law are definitely its origins, you might in fact have already encountered a lot of non-discrimination law in other subjects. First of all, studying national labor law, of course, but also maybe when you had a class on human rights, fundamental rights, or even general EU law class. All right. So for this reason, many of the things I will explain today might be familiar to you, in which case, lucky you. And second, we will be covering discrimination for 2 weeks, for 2 separate sessions. So today we will focus on discrimination between men and women. And next week we will focus on another ground for discrimination, notably discrimination on the ground of religious affiliation. Okay. So because of this, today we focus on one kind of discrimination between men and women. Of course, before diving in the different legal orders, which we will analyze today, the 4 which constitute the object of our class, first a moment of definitions to touch on 2 fundamental definitions for discrimination law, and you might already have heard those, so I will go rather fast. If there are any questions, as always, feel free to send them my way. So discrimination can present itself as 2 kinds of discriminations. These are defined in European legal orders as either direct discrimination or indirect discrimination. Now, direct discrimination is the easiest one to identify. For that reason, slightly less common, because even people who want to discriminate are generally smarter than that. So direct discrimination is the situation where one person is treated less favorably than another one would be in a comparable situation on the basis of a protected characteristic, for today on the basis of his, or much more commonly, her sex. So this is direct discrimination. Normally, I would ask you to come up with an example of direct discrimination in class. In this context, you can be slightly lazier, and I will tell you a very direct example is an employer saying, I do not hire women in my company. Okay, I don't want women in my company. This is a direct discrimination, very easy to identify. The difficult one, and also the more common one in case law, so the one to which you should be more attentive, is indirect discrimination. Now, indirect discrimination is the situation where a criterion which is apparently neutral, so a criterion which is apparently applied to everyone in the same way, has in fact a disproportionate effect on a group which is characterized by a protected characteristic, in our case for today, as a bigger impact on, let's say, women compared to men. Now, this is more common and also much easier to disguise as discrimination goes. To give you an example, again, I will give you a very extreme one so that it's easier to understand. Let's say the same evil employer of before. He does not want to hire women. But he knows that he cannot say that, so he will come up with a criterion that seems neutral, but in fact excludes many more women than men. For instance, he will say, our evil employer, he will say, I will not hire anyone who is not at least 1.85 meters tall. Okay? So of course, this is apparently neutral. Everyone is treated in the same way. But of course, if you go looking into the actual impact, this criterion will exclude a much bigger percentage of women than men. Okay? So this is the example of an indirect discrimination. And these two concepts are in fact used all across legal orders. And I'm sure that you have already met those in your national labor law class, at least. So let's dive in the different legal orders. Once again, the EU will keep most of our attention, but there are interesting differences in the approach to discrimination between the EU legal order and, to an extent, the European Convention on Human Rights and the ILO and European Social Charter. I will explain in a moment. So the ILO Declaration on Fundamental Principles and Rights at Work includes the elimination of discrimination among its main objectives. So it's one of the fundamental principles of the ILO and includes, for this reason, two conventions as fundamental. Okay, one is the Equal Remuneration Convention, Convention number 100, and the other is the Discrimination in Employment and Occupation Convention number 111. Both of these conventions, also because they are fundamental conventions of the ILO, have an incredibly high number of ratification all across the world. Always remember, as we saw in our, was it the second class, I believe, that there are around 190 something. I will not risk myself again with precise numbers. I believe around 192, around 196 members of the ILO. So most of them have ratified both these conventions. Convention number 11 ensures equal remuneration between men and women. And please pay attention to the wording. Equal remuneration for work of equal value. Now, this is particularly relevant as addressed by the Committee of Experts on the Application of Conventions and Recommendation in its general observation about Convention number 100 in 2006. Work of equal value doesn't mean the same work. And this is, as I told you, a huge difference in approach with the EU, which we will see in a moment. The ILO approach to discrimination is broader and in a way more akin to policy making than to human rights approach of individual justice. This is not just about ensuring that an individual has the same equal remuneration than a man doing the same job, but also that in general, men and women receive the same remuneration for job of equal value in society. And why this is relevant, and you can see in the first sentence in the slide, it's relevant in the context of what's called occupational segregation. Because, of course, there are industries, jobs, professions that are predominantly done by women. Imagine care work and other jobs which are predominantly male. So if you only compare the same job when in your quest for equal pay, these women in care work will only be compared to other women. So it will, a human rights approach, individual rights approach, will fail to identify the discrimination which is inherent in the fact that predominantly women, professions done predominantly by women are or might be underpaid compared to other work which is predominantly done by men, which is in a different sector maybe, but of equal value. Of course, this is a huge difficulty in identifying the value of a profession. And in a way, open parentheses, this is also very timely, because the present crisis we are living, in a way, has highlighted how a lot of value is created, essential value is created by professions that we generally don't value much in economic terms. Let's say people working in retail, cashiers at supermarkets, cleaning or deliveries, and so on. All these is generally low-paid jobs, called very often in a rather dismissive way low-skilled jobs. But you see now that they are actually making the world run, whereas high-paid managers and PR, marketing departments, and so on can safely work from home, essentially stop working without much of an impact. So finding the value, and I close my parenthesis, of work is a hard and necessary social endeavor. But the approach of the ILO encourages member states to look at this, to look at the actual value of jobs, to see that jobs of equal value for society are paid the same, even across companies. Okay. And we will see how this is different from the EU approach and similar to the European Social Charter. Now, to be a little bit faster on the rest, Convention number 100 has a broad definition of what remuneration is. So equal remuneration for a job of or work of equal value. Remuneration has to be conceived as very broad. All bonuses, etc., 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 are included. Convention 111 provides also definition of discrimination, which does not only cover sex, but also a series of other grounds. As I told you, we will see an example of these already in the homework at the end of this video, but also next week. And Convention 111 also provides for the possibility of justifying a difference in treatment, what is called a distinction. So someone can be treated differently and not be a discrimination if this is based on inherent requirements of the job. Now, as promised, we go to the European Social Charter. The European Social Charter includes a few provisions that are essentially of non-discriminatory nature. There is the right of equal pay for work of equal value, same as we saw in the ILO, and there are also other grounds protected against discrimination, migrant workers, persons with disabilities, and a general article about discrimination based on sex. And you also have an horizontal provision, Article E, which provides that all the rights protected by the Charter, must be applied in a non-discriminatory way. So as long as something falls in the scope of the Charter, non-discrimination applies. We will see a very similar situation with the European Convention of Human Rights, and we will spend a few words more about that. Now, there has been a very important case, Autisme Europe against France, in front of the European Committee of Social Rights. It deals with education of children with autism. So it's, let's say, not in the scope of our course. But in this decision, the committee clarified a series of things about non-discrimination. First of all, that Article E is not autonomous, so you need to prove that there is another right of the Charter which is applicable, but also that the grounds listed in Article E, I will take it again, the list is actually an open list. So if you read the grounds protected, sex, language, religion, blah, 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 but you see at the end or other stages. Okay. So if you check this list, you will not find, for instance, disability. But the committee said, well, there is other stages, so we consider that disability is also protected under Article E, right? So it's an open list, keep in mind. If in the future new grounds for discrimination were to appear, the European Social Charter is ready to accommodate them. Now, if you look at these conclusions about Portugal, you will see the same approach of the ILO, which I just described. So when you are looking for discrimination, the comparison, says the European Committee for Social Rights, must extend to other enterprises. For the same reason, last sentence of the slide, otherwise enterprises which are largely female oriented, where the workforce is made of women, will be in a way forgotten because they do not have a comparison in the same company. So again, the European Social Charter, just as the ILO, has a broader approach, policy-minded approach, which encourages legislators to look at the broader world of work when ensuring non-discrimination. If you don't do that, if you don't look at the broader picture, of course, it's very difficult to actually have equality in terms of difference of treatment between men and women. And as long as female-dominated industries are generally less remunerated, less valued by society in terms of remuneration, you will still have differences, although a man and a woman working at the same company might have the right to the same remuneration. Final point about the European Social Charter, but this is a point that extends also to the EU legal order. We will not come back to this when talking about the EU. We already have quite a lot to talk about, but keep this in mind. You will find it also in the directive that is on eCampus. Check it out. It's the protection against retaliatory measures. So if someone brings an action for discrimination against her employer, or if someone testifies as a witness in the same action, they should be protected against retaliatory measures. And in particular, they should be protected against being dismissed by the employer. And this is a very strong protection against dismissal, because the committee says, and also EU law says, that this dismissal, if someone is dismissed because of the action it brought for discrimination, the person should be reinstated. So it's not just monetary compensation, she should have her job back. Okay. So it's a particularly strong form of protection. Coming now to the European Convention of Human Rights, we also have an horizontal provision, Article 14, just like the European Social Charter, that says that the application of all the rights protected by the Convention should be non-discriminatory, and it also provides a series of grounds which are protected, and also an open list, as you can see, the last words or other stages. So it's also an open list in case a ground is not immediately included in Article 14. So the question is Article 14 essentially superfluous measure? Because if you have to find another article that applies in order for Article 14 to apply, then why not rely directly on the first one? Okay, let's say Article 11, our right to the freedom of association, which includes the right to strike and to collective bargaining. Why just not argue for a violation of Article 11? Well, the court has clarified in Sommerfeld versus Germany that the difference lies in the fact that Article 14 does not presuppose also a breach of the other article. So it's the application of national legislation related to the freedom of association that should be non-discriminatory, although the national legislation is not itself in breach of Article 11. So even more clarification in Clift versus UK. You have to imagine a minimum of rights, a floor of rights protected by the European Convention of Human Rights that the state must guarantee, of course. So guarantee the right, the access to collective bargaining. Okay, so this is the minimum. Okay, Article 11, you're fine. But suppose that the same state, in saying that, yeah, everyone has the right to collective bargaining, but workers working part-time, they are not covered by collective bargaining agreements, So although the national legislation protects Article 11, there is a possible discrimination there because you have mostly women working in part-time. So Article 14 might play a role there. Okay, so you need to fall into the scope of the rights protected by the convention, but you don't need to also have a breach of a right protected by the convention. Okay, so Article 14 is not just a parasite of other rights, it's also something that has an autonomous importance. Two examples here about social rights. This is about the raising of pensionable age for women in the UK. So for many years, in many European countries, there was a different pensionable age for women compared to men, generally lower. And it was justified for various reasons, family charges, maternity leave, and so on and so forth. But at a certain moment, many countries, most of them, all of them now, have raised the pensionable age for women to have the same age for pension as men. So the question was this difference justified or discriminatory? And the Court of Human Rights said, yes, for a long time this was justified by the economic situation of women in the labor market. But since this has changed or is changing, now it is justified to raise the pensionable age at the same level. Second example here was in the context of disability benefit, but the content is not so much our point here, it's more the method. The Court of Human Rights accepts statistics as evidence to prove indirect discrimination. So in the past, you can see it in the slide, in the past it was slightly cautious about that, but in a more recent case, it has confirmed that yes, you can rely on statistics to prove indirect discrimination. What does it mean? This is an important point also for EU law, so I will deal with it now. But remember that this is applicable also in the EU legal order. We will also come back to this. So statistics are extremely relevant to prove indirect discrimination. Let's go back to the example I did at the beginning. Okay, the employer would not hire people that are shorter than 1.85 m, and I said this is indirect discrimination because it has a disproportionate impact on women. How can I say that? How can I prove that, yes, the impact will be much greater on women? Well, statistics. I can prove through statistics that the average height for women is, I don't know exactly how much, but it's surely lower than 1.85 m in most European countries. So, statistics play a fundamental role in proving indirect discrimination, in proving the disproportionate effect. Okay? And the Court of Human Rights accepts now these statistics, and even more importantly, if the statistics are sufficiently reliable and significant, let's say our statistics about height, then they give rise to a presumption of indirect discrimination, so a reversal of the burden of proof. It will be up to the employer to prove that no, this criterion of 1.85 m is not discriminatory because it's based on an occupational requirement, etc., etc. Unlikely in this case, but this is how it works. So if you can prove a suspect of discrimination based on these statistics, then there will be a presumption of indirect discrimination and a reversal of the burden of proof. It will be up to the employer to prove that this measure is not discriminatory. We will see this again in the context of EU law, and this is the perfect segue. Here we are with the EU legal order, which constitute again our main cause for today. Now, in the context of the EU legal order, as highlighted by Catherine Barnard, who is one of the most authoritative voices in EU labor law and EU law in general by now. So the protection against discrimination between men and women has been one of the most highly developed areas of EU law in the social sphere. And in general, it is mentioned as one of the greatest contributions of EU law to the evolution of national labor laws in general. Okay, so keep this in mind. This is one of the strongest protections granted by EU law in the context of labor and social security law. It's often cited as such. And we have seen when we dealt with the history and the evolution of EU labor law how important that was and how old, in a way, this is in the EU legal order. If you don't remember this, it was lesson 1, so you can go back and check. So in the Treaty on the Functioning of the European Union, you have Article 157, which enshrines the principle of equal pay between men and women, and it has been there since the beginning of the European communities we have seen together. The same right is also enshrined in the Charter of Fundamental Rights in a broader sense, not just related to equal pay, but also in all areas of the life, in fact, and specifically in employment, work, and pay. Again, specifically mentioned. Continuing in this importance, the European legislator can enact legislation in this area following the ordinary legislative procedure. So compared to other areas, relatively easy. The evolution of the case law on the equality between men and women starts with a milestone judgment, which is Defresne. It was the second case brought by Miss Defresne. Interesting, since you are studying at the University of Liège. I cannot even say since we are in Belgium right now, because you might not, I am not, for instance. Anyway, since you're studying in Belgium, this is a very important case in the very history of Belgian relationship with EU labor law, because this case was brought by a Belgian lawyer and academic and feminist and activist for the feminist movement, Eliane Vogel-Polsky, who was one of the first to recognize the legal power of EU law to advance the cause of equal treatment between men and women. And in particular, it was in Defresne that the Court of Justice recognized that, yes, Article 119 of the treaties of the European communities was the Treaty of Rome. Sorry, I couldn't remember the name of the Treaty of Rome. Could have indeed a could be directly invoked. Here, this is not the context, the content which is important for us, but also the reasoning of the court. So this article had this double nature. We saw it in the history of the EU. The first here in the French, the first nature is economic. Okay, is about competitive advantage in intra-community competition. We already talked about this in our first class. There were concerns that countries where this principle was already in place would be at disadvantage in competing with countries which had not this principle. Let's say the French textile industry, where the principle of equal treatment was already present, against the Italian textile industry, which did not have this principle in place. But also, and this is the interesting, you see, double nature. The second nature of these rights to equal treatment is a social objective of the community. Okay, the ensuring social progress. So not just economic, but also, secondly, social. These evolved in more recent cases where the Court of Justice confirmed that now the economic aim of the same article had been, in a way, had become secondary itself to the social aim and to the fundamental nature of the right to equal treatment, the human right, in the words of the court. Okay, so it goes from an economic right to a human right, the equality between men and women. As I said, this is an area where you have very important legislative action of the EU. I will not read all the content of this slide. You have the slides in PDF on eCampus. So you have a large number of directives, culminating with the more recent one, Directive of 2006, the Framework Directive on equal treatment between men and women. Okay, so this is your reference for all cases related to discrimination between men and women. And this is an area of law which is Europeanized to a very large degree. So if you study EU law of discrimination between men and women, you will find the same concepts and most of the same rights and remedies in your national system. So it's a very useful, practical area to study also in EU labor law, because everything you study here is useful in your national situation. And in fact, if you already studied your national legislation on non-discrimination, you will find many similarities. So the concept is that direct discrimination, the easy one, let's say, is forbidden always, unless in a very difficult justification where there is a genuine and determining occupational requirement. Sometimes you can find it as an acronym as GOR, the genuine occupational requirement. Okay, this is of course a very high bar to justify. Again, going for very straightforward examples. Let's say you are an employer, someone who is making a movie, and you want to hire an actor for a female role. Well, it's okay if you discriminate against men for that role, because, well, they have to play a woman. So in this case, you have a genuine and determining occupational requirement. But this is a very strict exception. Okay. Otherwise, in general, direct discrimination is forbidden. Indirect discrimination is also forbidden, but the justification is somewhat easier. And if you read it in the slide, you will find an immediate similarity with the proportionality test, which we studied in the context of fundamental rights. So you have indeed a proportionality test of the discriminatory measure, must be objectively justified, have a legitimate aim, and do not go beyond what is necessary to achieve that aim. Let's make an example again. Okay, let's consider a job which is a physical job. Okay, a job where you have to be strong and physically fit, and you have to lift weights and so on and so forth. And the employer might say, well, I only want men for this job because you have to be strong, lift weights and blah blah. Okay, but this is of course a very broad exclusion, and it might be difficult to justify as genuine and determining occupational requirement. Another way to do this, of course, and a more proportionate way to do this, is to, for instance, include a physical test in your hiring process. That way, there might be, and there are in fact, women which are stronger, faster, and more resilient than men. Okay, and with a test, you can be proportionate in your application of this difference of treatment. Okay, and this might pass the scrutiny if the job is in fact physically demanding. Now, to see a few applications of these principles. Okay, I told you there was different application between EU law and the ILO and European Social Charter legal orders, and you can see here stretching the boundaries a little bit. This was a situation where a woman was hired to replace a man. Okay, and she would be paid less than the man she was replacing. The question was, can she choose this man who no longer works for this employer as comparator? Okay, can she compare her situation to this man? And the Court of Justice said Yes, you can. So you see, the comparison is not strictly limited to other people working for the same employer, but the Court of Justice still says equal work for the employer. It's not work of equal value. It is limited to doing the same job for the same employer. Okay. But not necessarily at the same time. So asynchronous, let's say, comparison are allowed. And as you can see, confirming what I just told you, the Court of Justice says within the same establishment or service. Okay, so no possibility to look outside the company to actually have emerge situation of, for instance, segregation, which we saw in the ILO in female-oriented professions. Seymour Smith, I will cover very quickly. It's the possibility of using statistics, but I've already said quite a lot speaking about the European Convention of Human Rights. So yes, the Court of Justice accepts statistics to prove indirect discrimination, and you have, of course, to prove that in this case, a smaller percentage of women are able to satisfy the condition. If you're curious, this was the UK legal order where you had to have 2 years of seniority in the same company before enjoying protection against unjustified dismissal. And there was a case that argued that more men than women were able to reach these 2 years, condition. But the statistics were not that clear. The difference was about, again, it's numbers, but I think I have the right ones this time. There was like 7% difference, so not a huge one. Okay. But still, the court accepted statistics as a way to prove indirect discrimination. And also the court said that you don't need a huge disparity immediately. You can also have a lesser disparity, a lesser difference, but persistent over time. In which case, it also might indicate an indirect discrimination. In this case, there were no such statistics, but again, these are the 2 ways. Either you have statistics proving a very different impact on men and women, or you have statistics proving a difference in impact over a longer period. Okay? Keep it in mind if you ever have to argue this kind of cases. And it also, keeping about the statistics, it also tells you a lot how the, even in the practice, not just in academic research and so on, in the practice of the law, in this case non-discrimination, huge area of the law, how the law is necessarily interdisciplinary and how you must be ready and able to at least understand a little bit of statistics and so on. So you see, interdisciplinarity is not just something which is nice to say at university, but it's also something very much interconnected with the practice. So either you understand statistics quite well when you have to provide advice to a client, or you have to find someone who understands them well, and in which case you might also have to pay them. So here it is. Good reason also to pay attention to your non-legal classes during your studies. So a few examples of application. This was a case about part-time. And the Court of Justice accepted statistics proving that many more, but to a very large extent, many more women were working part-time than men. So a difference in treatment of part-time workers, in this case the exclusion from occupational pensions, was also a discrimination, direct discrimination against women. And this, of course, was very important before the directive on part-time work, which we saw, and only arrived, the directive on part-time work only arrived in the 90s. So before the directive, in order to ensure the equal treatment of part-time workers, well, non-discrimination of women was a very powerful tool, because part-time work was mostly a situation which was impacting women. Okay. You also see a little bit the paradox of non-discrimination, because since more women than men were doing part-time work, it was possible to invoke non-discrimination and protect part-time workers. But suppose that the same number of women and men were working part-time, then you could have discriminated part-time workers as part-time workers, of course, before the directive on part-time work. So this is a little bit the paradox of non-discrimination. If you can prove that there is a ground for discrimination, in this case, difference of treatment between men and women, then you have a very powerful tool at your disposal. But if it is only a discrimination based on something else, discrimination, let's say, based on your employment condition, part-time, not part-time, you don't have access to this powerful tool. Jorgensen confirms what we also saw in the European Convention, under the European Convention of Human Rights. If you have statistics proving the difference of impact, then the employer has the burden of proof, and it will have to justify the difference of treatment under the proportionality test, which we saw a few slides ago. In Danfoss, very nice, very precise decision of the Court of Justice about criteria for promotion. So what kind of criteria can an employer take into account when deciding for promotions? And there were three criteria examined here by the court. The first one is the most difficult one, is the criteria of mobility. Fun fact, in the French version of the decision, the same criterion is called flexibilité, so flexibility. And in the English version is mobility. So can the employer take into account the mobility of workers when deciding promotions? And mobility is a very dangerous criterion, because of course it might mean different things. It might mean that the person was ready to adapt, as you can see in the code, and move from one service to the other, do different things, in which case it's okay, says the court. But it might also mean for the employer that this person was ready to work just more, or let's say outside normal hours. Let's say the employer says, oh, I want to give the promotion to Mr. John Smith because he was ready to work at 8 p.m. He stays at the office in the evenings and so on and so forth. Whereas Mrs. Jane Doe, she goes home at normal working time, let's say at 6 p.m. And of course she does, because she is the primary caregiver of the family. All right? In consider that in society, tasks about care and family management, household keeping, and so on are still generally much more falling upon the shoulders of women. So if it is used in that sense, so availability outside of normal working hours, then it's not accepted by the Court of Justice. The second criteria is training. You have a degree or not. The court says yes, but only as long as it's relevant for the tasks that are up for the promotion. And finally, the criterion of seniority, length of service, is okay for the Court of Justice. You don't need to justify the use of these third criteria. So you see, very nice scale of problems with different criteria. As I told you, that the Court of Justice is aware of the social division of labor, and that the domestic tasks and works of care are more often than not done by women. So the court knows this, and this is very relevant because the court is ready to accept that this uneven share of work has an impact on, for instance, the fact that more women than men are working part-time. Okay. Now the question in Rinke was one about medical training. So medical training, I believe this was a Danish case, I'm not sure, but required a certain amount of periods of full-time training. So you could do your training part-time in general, but there were exceptions. So certain periods you had to work full-time. And there was a person who said this is discriminatory because I have I am the primary caregiver in my family, I have family duties and so on, I cannot do these full-time training periods. Why can't I do it part-time? This is discrimination. But the court said that because of the medical training is actually the object of EU law, because we need to have the same medical training, minimum requirements of medical training across Europe, because then when you are a medical doctor, you can move in other countries. So there are other rights protected by this. In particular, the court invoked here, I didn't put them in the slide, but paragraph 38 talks about free movement of workers. So the fact that medical doctors can go to other countries, so they have to have the same training or at least minimum requirements. And to health, the protection of health, consider that yes, member states were in the margin of discretion when asking for full-time training periods. So this was not. This was a measure which had a bigger impact on women. The court said yes, but it was justified. There were objective reasons and it did not go beyond what it was necessary. So this was our last examples. Of course, the case law on discrimination between men and women is huge. So if you're interested in this, I can also provide for more information about that. But for the moment, let's go to your homework. I have been receiving more reactions about the video on atypical work, and you still have 1 day or so, 2 days to send in reaction. Please continue. Very happy to answer all your questions. This time, I will ask you to read 2 decisions. Don't worry, they are very short, 19 pages in total. 2 decisions dealing with the different protected criteria. So we are moving to other areas of discrimination, which is discrimination based on age, which is more slippery as discrimination ground. In fact, now that I think of it, I have another question for you, which is not in the slide. So I need all your attention. My other question is, why is discrimination based on age different from, let's say, discrimination based on sex or on race, to have the easy ones? Okay? Why discrimination based on age is different? And why is it possible for people out there to argue that there should be no such a thing as non-discrimination based on age? Why is it problematic? Come up with ideas. Be the devil's advocate. I don't care. Shoot your ideas, and I will discuss them in the reaction video. So for the rest, read these 2 decisions. You will see in Kucuk Devesi, again my wonderful pronunciation of Turkish names. You will see how EU law creates a very powerful tool in the hands of national courts. Which one? And then you will read IOS, also called Dansk Industry, and you will see how this powerful tool then creates other problems in practice. And do you think that these problems are worth it or not? Okay. Or should we rein in this powerful tool? Okay, so identify the tool and identify the difficulties arising from the use of this tool. Supposing, again, that you are very disciplined, which I encourage you to be, to keep some sort of schedule if you are also in lockdown, just as me. If you're watching this on Friday, then, of course, I expect your reactions by the following Wednesday. What's the date of next Wednesday? Yeah, I'm using a new software, so now you can see me checking the calendar. So this is supposedly for Friday 27. So I expect your reaction before Wednesday the 1st of April. It's not a joke. Really, send in your reactions, please. So, okay, this was all for today. Stay safe. I wait for your reaction. Keep sending in your questions. Thank you very much. And, well, if you're watching this on a Friday, have a very nice weekend.
Got 3 more days till I can take a break, rise on my boat, see if this little bit of love will grow.